So, say for instance, and I think you and I both have a lot of clients like this, where you have a client with properties abroad, a property portfolio in multiple countries. They are domiciled in South Africa. It's a married couple, and you can please just elaborate there on the effect, whether they married in or out of community of property. And they now want to do a will because they want to figure out where everything should go. How do you do this, and how would you handle a situation like that when you have properties in multiple countries?
Sure. So there's different. So there's many different types of permutations, especially when it comes to like being in community of property, out of community of property, and what sort of like structuring that you have in place. So, how are you buying these properties? Are they typically being held in companies, in trusts, and that sort of thing? And when you speak about the international landscape, I think the first point of departure is for everyone to realize that different countries work differently. And so your South African laws of testation or testation planning, death, executorship, whatever you want to call it. So when you die, something has to happen to your estate. Now, every country has different laws that govern that. So you'll find, for example, certain countries might have forced testation, where you have to leave a certain amount to the kids. You can't voluntarily hand out to whoever you want. Whereas South Africa doesn't really have that. There are certain cases where children have succeeded in overruling a will and getting some of the money to themselves, but it's actually not the norm. The norm is that if you want to leave your estate to a charity, you're more than welcome to. And unless this child has some kind of claim for support or maintenance, then they can lay a claim against the estate. But typically, you can leave your money wherever you want. Other countries don't work like that. There's even countries where females can't inherit. So if the will, and so the relevance of this is if you're drafting a South African will where you leaving everything, let's say, to a female daughter, that's not necessarily going to apply in certain countries where that's not allowed. So the will is going to be declared void. So then what lands up happening is you're sitting with an estate in the foreign country and an estate here that are being dealt with very differently. And they're using those laws of testation as opposed to what you really wanted to happen. So what we normally suggest right from the beginning as a point of departure is treat your assets in each country separately. Once we understand what each country has, we can then start looking at the implications on joining them up from a tax perspective and what this would look like. So if it's dealt with in that country and it comes back into South Africa and it goes into the hands of a trust, what does this look like? If it goes into the hands of an individual, what does this look like? But first, you need to ring fence your assets in that country, understand what their laws of testation are, and you need to make sure that your wills don't contradict each other. So, for example, if you go to a South African estate plan or somebody that, like a lawyer that does wills and things like that, one of the typical clauses we put in is to say that all other wills are revoked. The reason we do this is because we don't want this will to just appear as like an addendum to previous wills and just like, because then there's going to be conflict. So we revoke everything. That is not an ideal situation to be in. Apologies, my camera just went off. That is not an ideal situation
I thought you were just showing off your new brand.
That's not an ideal situation to be in, for example, if you've got an overseas will and you're using your South African will to revoke that. Because the overseas authorities are going to want to know what the latest will is. And theoretically, if it's been revoked, and now you're stuck to the South African will. So best advice I can give out to people is treat each country separately. focus on drafting a will for each individual country, and then we can bring it together from a tax perspective, find out what the tax looks like in that country, and then what South Africa, how South Africa treats any income or any assets coming in, what this would look like from a South African perspective. But that's the best advice, because remember, South Africa does still tax on income from overseas. So another thing that we need to look at is if there's any double tax agreements between South Africa and that country, because if you don't want to get double taxed, so that's a big issue. So if you're bringing money over and there's income that's being generated, we need to understand what the relationship between the two countries are, so we can design their state around it and do a bit of planning.